We've been following the bouncing ball here for a little while. We know that there was this theory that under the insurrection clause of the 14th Amendment, that some people were arguing, college professors and others, saying that Trump should not even be allowed to be placed on the ballot, saying he was already disqualified because January 6th happened, and there's this self-executing made-up feature of the Constitution that says that just like somebody who's under age 35 or somebody who's not a natural-born citizen, they can't ever even apply to be put on the ballot. Those are qualifying features. They're also saying that a disqualifying event may prevent you from qualifying to be on the ballot. In this case, insurrection is the disqualifying event. And this is a lawsuit that has been filed by a Florida man now to keep Trump off the ballot. The theory emerged. It was discussed and published by MSNBC, Judge Luttig in Lawrence Tribe. We saw the GOP pick this up and ran with it with Asa Hutchinson at the debate. Trump may not even be qualified to be on the ballots. Now the actual lawsuit has been submitted. You see here, it is 7 pages filed out of the Southern District of Florida. The case is Lawrence Caplan versus Donald Trump. This guy's a lawyer, evidently, and let's see what he says. Petitioner Lawrence comes before this court seeking declaratory relief, asking the court to do something, just to make a declaration on the specific issue of whether candidate Donald John Trump is indeed constitutionally prohibited from seeking a second term as president. Encompassed within this request for a declaration is a further determination as to whether Trump is indeed even eligible to participate in the primary in the spring of 2024. Bringing this request for a declaration, they say that me, Lawrence, has carefully studied the specific provisions of the Constitution which govern whether an individual who participates in an overt rebellion or an insurrection against the government is effectively disqualified from service in the federal government as president. Done some studying here. For purposes of standing, they say this man asserts that he has actively participated in the last 12 presidential elections dating back to 1976, when he cast his first vote at the age of 18. It should be noted that in the course of these 12 presidential elections, Lawrence has voted for both Democrat and Republican tickets and was a registered independent for many years. He's a legal resident of Florida and a member of the Florida Bar, he's a lawyer, and a bar of California, Oregon, currently a member of the Tax Court, Southern District of Florida, Court of Appeals, and the U.S. Supreme Court. Never been sanctioned or suspended. The facts of this case, writes Lawrence, are undeniably simple. Donald Trump served as the 45th president of the United States, having won the election and being inaugurated. 4 years, but Trump chose not to appear at the inauguration of Biden, having left his estate for South Florida. What, is he upset about that or what? On January 6th, after giving a speech to a throng on the ellipse near the Capitol, Trump exhorted the throng to march on the Capitol and told them that he would be right there with them. After he finished with the speech, Trump returned to the White House and watched the events unfold, as he said. As we're all well aware, the throng marched on the Capitol, forced their way to the Capitol building, ransacked the Rotunda area, even made their way into several offices of representatives and senators. Yeah, this was the same event that Ray Epps was at, screaming, "Let's go into the Capitol." He was there, never got charged. Nancy Pelosi was there, filming the whole thing. We know that from the Proud Boys trial, the defense there alleged that there were at least 50 undercover informants, not from the FBI, but from Homeland Security investigations called HSI. You remember that event. As the confirmation of the results were being undertaken in the House, alarms went off. Members scurried. Of note, Vice President Mike Pence missed being reached by some of them by a matter of seconds, he says. Eventually, several high-ranking members were shuttled to a safe area. Of note, President Trump had sent out a tweet that day, says, "We'll be wild." And he remarked that the insurrectionists are special and that we love you. Did he say that? Did he say, "We love insurrectionists" in his tweets? He later remarked that Vice President Pence simply did his job, and so on. Now, what we're seeing here is sort of looking like a rant a little bit. Since the events of January 6th, hundreds of insurrectionists have been charged and tried, which is a very tiny number relative to other jurisdictions. Recently, Special Counsel Jack Smith has been appointed. Trump was arraigned on these charges, and so basically I think he's making the argument that he's been arraigned. He now awaits trial sometime in 2024. It should be noted that Trump has also been formally indicted on charges of secret documents, classified documents, which is a federal offense. And we have another typo, man, another one, and has also been indicted in Manhattan. However, none of these crimes have the effect of preventing Trump from seeking re-election in November. So here's where he gives us the law now. All right, this is a lawyer. He says the 14th Amendment to the Constitution, ratified 1868, shadow of the Civil War. Section 314th automatically, you see this, automatically excludes from future office any person who has taken an oath but acts to rebel against the charter, either via overt insurrection or giving aid or comfort. It says, in carefully analyzing the language embedded in the Constitution, numerous legal scholars have wrangled with the preeminent issue of whether an actual conviction is necessary to trigger the prohibition of running. It's the disqualification clause. Has been determined, they say, to operate completely independently of any criminal proceedings, also independent of impeachment and Congress. Wow, it's a magical clause. It's just, it's a miracle. It operates on its own. And it's weird, you know, like we just found it. The country's been around for a while. We just discovered this though. And what's so awesome about it is it's the perfect thing we need to take out our political enemies. Isn't that fun? Now, former federal judge Michael Luttig of the Court of Appeals and noted legal scholar Lauren Tribe, okay, I'm pretty sure his name's Lawrence. Yeah, it's Lawrence. Definitely Lawrence. It's not Lauren. Have come to the inescapable conclusion, the disqualification clause. Okay, so first of all, Judge Luttig is an idiot, in my humble opinion. And, you know, Lawrence Tribe is, let's say he's partisan and overtly biased. Yes. Here, they've both come to the inescapable conclusion that the disqualification clause was designed to operate directly and immediately upon certain individuals named Trump. I wonder if did the founders write Trump in there too? Who betray their oaths to the Constitution, whether by taking up arms or waging war or by attempting to overturn the results of an election through a bloodless coup. I don't remember any of that language in the Constitution. I don't remember it. Where'd these guys find it? It's incredible. They like read through, it's a miracle. They say Trump's efforts, both in Washington and Georgia and other states, as well as the assault on the Capitol, put Trump at the center of the disqualification clause. And as a result of which, make him ineligible to ever serve in federal office again. Oh man, he probably was really enjoying writing that. Never again. Now, given the facts that seem to be crystal clear, it seems to be crystal clear that Trump was involved to some extent in the insurrection that took place. Sole remaining question is whether American jurists who swear an oath to uphold the Constitution upon their entry to the bench will choose to follow the letter of the Constitution in this case. Of note is that during his one term in office, Trump appointed 3 justices, Gorsuch, Kavanaugh, and Amy Coney Barrett. Shout out to some good judges who are viewed as conservative jurists who err on the side of a strict construction of the Constitution. They overturned Roe versus Wade. And so therefore we must look at the strict interpretation because they use the strict interpretation. Interestingly, Section 3 of the 14th Amendment, which provides for disqualification, has remained on the books for 150 years. While one can argue it hasn't been tested, the fact that we have it is because we haven't faced an insurrection before. And Trump has since made statements to the effect that should he be elected, he would advocate for the total elimination of the Constitution. Trump said that? Trump said that if he's elected, he's going to have total elimination of the U.S. Constitution. Trump's going to create a new charter more in line with his personal values. Oh, I had no idea. Wow, interesting. I didn't realize that was a thing. Is that part of his new campaign? Incredible. So the 14th Amendment was promulgated and ratified in the context of the Civil War. Any number of top scholars, including Judge Luttig, who's not that intelligent at all, can hardly talk, and Lawrence Tribe, there we go, got the name right on that one. They conclude that Section 3 requires absolutely no legislation at all. No criminal conviction, no judicial action at all. It's just automatic. Trump is disqualified. So look, I know that this lawsuit's kind of goofy and we can kind of laugh and joke at this, but this is just the first draft, my friends. There will be a lot more like this. And the next ones aren't going to be so jokey and they're not going to have typos and they're going to have citations. All right. This is just the rough draft. In legal terms, Section 3, they say, is completely self-executing. Happens on its own. No presumption of innocence, no due process at all. They conclude that disqualification subject to Section 3, another typo, does not constitute a punishment or a deprivation of liberty. We're not depriving you of anything. You just don't qualify. Just like if you're 26 and you want to run for president, we're not depriving you of anything. You just don't meet the qualification. You don't have an absolute right to serve in office. And so all we need, also, as a second point on this, even if this lawsuit is goofy, almost doesn't matter. You just need a Judge Chutkin to stamp it. All right? You just need a judge to take a look and say, I like your argument. There are good highlighters here. Nice notepad. And they just stamp it. That's it. Then one Secretary of State decides, boom, got what I need. Then it's going to fall like dominoes. They're all going to start doing it. Lastly, the scholars conclude, he says, that Section 3 is expansive. It's all encompassing. And it really defines insurrection or rebellion against the constitutional order. Very broad. It says, taken along these same lines, had it been conclusively proven that Obama has not been born in Hawaii, the Constitution would have barred him from seeking presidency because he's not natural born. And petitioner is convinced that there would have been no wiggle room. He's saying, I would have found this same principle against Obama, by the way. That's how you can know that I'm credible. Furthermore, had President Trump merely been thought by many individuals to have engaged in an insurrection, that would have not sufficed. Merely been thought by many individuals, that would have not sufficed. However, the fact that he's been formally indicted, okay, so that's the line. So that's weird. So there is some process. The fact that he's been formally indicted for various felonies, including insurrection, mandates that this be triggered. Okay, so it's not actually automatic. So something triggers it. In this case, it's the filing of the felonies. So that, I mean, somebody's got to do something. The bottom line here is that Trump both engaged in insurrection and gave aid and comfort to others. Assuming that the public record is accurate, with no evidence to the contrary, this lawyer, who's licensed in multiple states and the Supreme Court, says Trump is no longer eligible to seek the office of the presidency. This court has the innate power to rule that the Constitution, the tenets, require to find that Trump and his actions with January 6, aiding and the fact that he's been indicted, effectively disqualified him from becoming president, effectively bars him from seeking the GOP nomination in Florida. We're asking for a declaratory judgment so that it's abundantly clear what happens. We're asking that you follow the language of the Constitution, and this decision should be relatively easy. So, Your Honor, please enter a declaratory judgment saying that Donald Trump is barred from seeking the office of the presidency and the primary, signed by Lawrence Caplan, Florida man, filed in court, federal court, Southern District of Florida, where certainly he has standing and where Trump resides. We'll see where this case goes, but yet another attempt to keep Trump off the ballot because, well, they don't want him on there. You see, here's the summons, personal service on a natural person. Donald Trump is going to get served here. A lawsuit has been filed against you. You've got 20 days to respond. Sued by Lawrence Caplan, and we know that the lawfare game will continue. This, my friends, I think is a real serious threat. I think that there will be a lot more of these filed, and all they need is one. They just need one judge somewhere to grant it, and then they're going to say it's precedent, and the rest of the dominoes they'll say must fall, because that's what the Democrats want to do, is keep him off the ballot, because if they allow the people to vote on him, somehow that's undermining democracy by allowing us to participate. So we'll continue to cover it. I think this is the first attempt of many. Thank you for subscribing, as we do.